Good morning, everybody. Well, it's morning here in Galashiels. First of all, apologies. As you can see, traditional in my family is that my daughters get me the most garish shirt that they can find for Father's Day, and I think they've surpassed themselves this year. So anyway, you'll have to forgive the shirt, Father's Day and all that. And before we get on to the main topic this morning, just want to thank everybody that was involved in the Justice Rally, the organisers, the hosts, the guests, everybody that tuned in. Thought it was a huge success. And in particular, I must congratulate, begrudgingly, obviously, Jane Sharp and Linda Kay for trouncing me at Mastermind. Apparently, the final score was 26-0. So, well, not to worry. I will get over that eventually. I did at least have the satisfaction of completely shutting up the dude when it came to Captain Crunch a few days previous to Rally, and I haven't heard a peep from him since. Surprise, surprise. Obviously, one of the things that myself and other YouTubers try and do is contact people who have an interest or are involved in the case. And so I managed to get in touch with, thank you. I've managed to get in touch with Dr. Richard Leo, and I'm hoping at some point to invite him onto the channel to discuss further. So I thought, I've already done a series of articles about Richard Leo and his work with both Steve Drizzen and Brian Cutler. But I thought it would be good to have a look at this particular document, which I believe is from 2009, when by now Brendan has Steve and Laura as his attorneys and are in the appeal stages, the original appeal stages, and this is before Judge Duffin's decision. It's interesting, isn't it? We, as I say, we invite people to come on and join us, and some do, and some don't. Some don't respond, and some are very good. Interesting that every single invite to a guilter to come on and discuss this case, not one. As I said, they would first of all need to answer two very simple questions. Why was the contents of Brendan Dassey's computer not used against him when Ken Kratz said that it's Brendan Dassey's computer? And why was Mike Holback grieving days before, whilst Teresa is still only a missing person, days before the cremains are found? So anyway, of course they will never come on because they cannot possibly explain that. They try and say, oh, well, it was a slip of the tongue. No, they don't. The family members are the last ones to accept that anything's happened to them. But equally culpable, I think, are the journalists who should have looked at that immediately and said, wow, that's big, that's huge. As I say, if Stephen Avery had been the one saying the grieving process could last days, weeks or years, that would immediately have been taken as being a confession, which I think is what we have to take it as from Mike. It's a confession that he knows what's happened, and he's inadvertently let slip. Anyway, so getting on with this document that I've got lined up, we'll just read through it. It's quite a long document. It'll take, I suspect, at least one or two parts to get through. But as I say, this is leading up to Judge Duffin's decision, and it was Ken Kratz himself, under the pseudonym of Charles Darwin, that first alerted me to the fact that Judge Duffin's cites work by Steve Drizzen and Richard Leo, when they look at the false confessions, convictions being overturned by a DNA evidence, and they did, as I said, they did a huge study of 125 cases of cases overturned in the post DNA world, where there were false confessions. Anyway, let's jump straight into the article. As I say, congratulations to Jane and Linda for winning. But anyway, we can move on and we can put that behind us. So, well, that was it. Yeah, the Woody Woodpecker Woody got in touch and left a message to say that Brendan should have taken the plea deal. Well, he didn't, but that begs the question: why didn't he take the plea deal? I'd like to know a few thoughts on why he didn't. I've got my own thoughts. Let's hear what other people have got to say about why didn't Brendan take the plea deal. Anyway, let's crack on with this and this. So here we go. This is the State of Wisconsin versus Brendan Dassey, the case number 2006 CF88, the affidavit of Dr. Richard A. Leo, State of California, County of San Francisco. So he's possibly somebody who'll know where Crunch Island is and will be able to help us on that as well. Anyway, let's carry on then. Dr. Richard A. Leo, being duly sworn under oath, states, first of all, his qualifications. So, number one, I am presently employed as an associate professor of law at the University of San Francisco School of Law. From 1997 to 2006, I was employed as an associate professor of criminology and an associate professor of psychology at the University of California, Irvine. From 1994 to 1997, I was employed as an assistant professor of sociology and an adjunct professor of law at the University of Colorado, Boulder. My educational background is as follows. I received a PhD in jurisprudence and social policy, specializing in criminology and social psychology from the University of California, Berkeley in 1994, a JD from the University of California, Berkeley in 1994, an MA in sociology from the University of Chicago in 1989, and a BA in sociology from the University of California, Berkeley in 1985. I am an expert in the area of police interrogation practices, the psychology of police interrogation and suspect decision making, psychological coercion, false confessions, and wrongful convictions. For almost 2 decades, I have been conducting empirical research and writing numerous articles and books on the subjects of police interrogation, psychological coercion, false confession, and wrongful conviction. In this time, I have analyzed more than 2,000 real-world interrogations. I am the author of several books, including Police Interrogation and American Justice, Harvard University Press 2008, and more than 50 articles and book chapters, many in leading legal and social science journals. I have won several awards for my publications, and my scholarship has often been featured in the news media and cited by appellate courts. To date, I have consulted with criminal and civil attorneys on more than 1,000 cases involving disputed interrogations and/or confessions, and I have been qualified as an expert witness 176 times in state, federal, and military courts in 26 states, including the state of Wisconsin, at pre-trial suppressions, motions, jury and bench trials, and post-conviction proceedings. I have testified for the defence, for the prosecution, and in civil cases. I have given numerous lectures to judges, defence attorneys, prosecutors, and other criminal justice professionals. I have also taught interrogation training courses and or given lectures to police departments in the United States, China, and the Republic of Cyprus. Now, let me just check just one moment that make sure that everything is going as it should be, because I'm always concerned about that I've not correctly put the stuff up on screen. It would appear as though I have. Let's carry on with his next. I have been retained by the Bloom Legal Clinic at Northwestern University School of Law on behalf of Brendan Dassey in this case. A current copy of my curriculum vitae is attached to this affidavit. Materials reviewed. I have reviewed the following materials: 2 audio CDs and accompanying transcript of Brendan Dassey's interrogation on February the 26th, 2006. 3 DVDs and accompanying transcript of Brendan Dassey's interrogation on March the 1st, 2006. 2 video DVDs and accompanying transcript of Brendan Dassey's interrogation on May 13th, 2006. Defendant's memorandum on Brendan Dassey statements in state of Wisconsin versus Stephen Avery. Marinette County Sheriff's Department supplemental report dated the 11th of November 2005. Wisconsin Department of Justice Division of Criminal Investigation report dated 13th of November 05. Calumet County Sheriff Department's reports dated 27th of February 06 and 28th of February 06. And a report of Lawrence T. White dated May the 11th, 2007. Of course, Lawrence T. White is the Larry White, who we see a couple of times in Making a Murderer. He was hired, one of the experts that was hired by Dean and Jerry, and unfortunately never got a chance to testify. A report of Joseph Buckley dated April the 4th, 2007. I'm not familiar with Joseph Buckley. I will need to find out. Trial transcript, Wisconsin Department of Justice investigative report. Now, this is interesting. News stories and broadcasts. So we know Tom Kircher. We see him. He was the one that in 03 detailed the completely bogus investigation into Stephen Avery, when it should in fact have been focusing on Gregory Allen. Anyway, Tom Kircher, Avery held on gun charge, case not linked to missing woman, DNA tests ordered on family. Doug Erickson, police, female bones, blood found at yard, key to Halbach's SUV found in Avery's bedroom, police say. The Teresa Halbach disappearance. Tom Kircher, Avery to be charged on DNA. Doug Erickson again, Avery to be charged with Halbach murder. Prosecutor dismisses notion of frame-up. Tom Kircher, investigators don't expect to find body of Halbach. Kevin Braley, homicide charge filed. Tom Kircher, evidence of slaying found early in search. Kevin Braley, Avery bound over for trial, and various broadcasts by WBA in November and December of 05. Part 3, the social scientific study of police interrogation and confessions. There is a well-established field. I'm just going to enlarge it a bit more. There we go. There is a well-established field of research in the academic disciplines of psychology, criminology, and sociology on the subject of police interrogation practices, coercive influence techniques, and confessions. This research dates back to 1908, has been the subject of extensive publication, hundreds of articles, books, and book chapters in peer-reviewed journals, is based on generally accepted principles, methods, and findings, is capable of validity testing, and has been generally accepted as valid in the relevant scientific community. The subject of police interrogation and false confessions is beyond common knowledge and something about which the public has misconceptions. Most people do not know that police detectives receive highly specialized training in psychological interrogation techniques, what these techniques are or how the techniques are designed to work, i.e. move a suspect from denial to admission. In addition, most people also do not know what psychological coercion is, why some techniques are regarded as psychologically coercive, and what their likely effects are. Moreover, most people do not know which interrogation techniques create a risk of eliciting false confessions when applied to innocent suspects, or how and why the psychological process of police interrogation can, and sometimes does, lead the innocent to falsely confess. In fact, most people are skeptical that innocent suspects will give or agree to false confessions to serious crimes in response to purely psychological interrogation techniques in the absence of a suspect's physical torture or mental illness. See Richard A. Leo, Police Interrogation and American Justice, Harvard University Press, 2008. This is because people view confessing falsely to a crime as an irrational and self-destructive act. Most people have no direct knowledge of or experience with psychological police interrogation and do not believe that they themselves could be made to falsely confess unless tortured. This skepticism and relative ignorance causes most people to assume that virtually all confessions are true and to presume that any defendant who has confessed is therefore likely guilty. Confession evidence, even false confession evidence, is therefore highly prejudicial, and once a confession is introduced into evidence against a suspect at trial, it almost inevitably leads to a suspect's conviction. Underscoring the prejudicial nature of confession evidence is that studies show that individuals who falsely confessed and chose to take their case to trial were convicted by juries 73 to 81% of the time before having their innocence proven. The social psychology of police interrogation. Once patrol officers receive the rank of detective, they typically receive intensive training in the practice and law of interrogation and thereafter learn to apply, refine, and hone their interrogation skills through extensive case experience, supervision, and/or additional training. Police interrogation is cumulative, structured, and time-sequenced process in which detectives draw on an arsenal of psychological techniques in order to overcome a suspect's denials to elicit incriminating statements, admissions, and/or confessions. This is the sole purpose of custodial interrogation. To achieve this purpose, interrogators use techniques, all of which are generally legal, that seek to influence, persuade, manipulate, and deceive suspects into believing that their situation is hopeless and that their best interest lies in confessing. Sometimes, however, interrogators cross the line and employ techniques and methods of interrogation that are coercive and thus regarded as legally impermissible. Contemporary American interrogation methods are structured to persuade a rational person who knows he is guilty to rethink his initial decision to deny culpability and instead choose to confess. Police interrogators know that it is not in any suspect's rational self-interest to confess. They expect to encounter resistance and denials to their allegations, and they know that they must apply a certain amount of interpersonal pressure and persuasion to convince a reluctant suspect to confess. As a result, interrogators have, over the years, developed a set of subtle and sophisticated interrogation techniques whose purpose is to alter a suspect's perceptions such that he eventually comes to see the act of confessing as being in his self-interest. Interrogators accomplish this by persuading a suspect to view his immediate situation differently, by focusing his attention on a limited set of choices and alternatives, and by convincing him of the likely consequences that attach to each of these choices. If successful, this process unfolds in two steps. First, the interrogator causes the suspect to view his situation as hopeless, and second, the interrogator persuades the suspect that only by confessing will the suspect be able to improve his otherwise hopeless situation. The first step or stage of successful interrogation consists of causing a suspect to view his situation as hopeless. If the interrogator is successful at this stage, he will undermine the suspect's self-confidence and cause the suspect to reason that there is no way for him to escape the interrogation without incriminating himself. To accomplish this, interrogators accuse the suspect of having committed the crime. They attack and try to undermine a suspect's assertion of an alibi or verbalization of innocence, pointing out or inventing logical and factual inconsistencies, implausibilities, and/or impossibilities. They exude unwavering confidence in their assertions of the suspect's guilt. They refuse to accept the possibility of the suspect's denials, and, most importantly, they confront the suspect with incontrovertible evidence of his guilt, whether real or non-existent. Because interrogation is a cumulative and time-sequenced process, interrogators often draw on these techniques repeatedly and/or in succession, building on their earlier accusations and representations at each step in the interrogation process. Through the use of these techniques, the interrogator communicates to the suspect that he has been caught, that there is no way he will escape the interrogation without incriminating himself, and that his future is determined, that regardless of the suspect's denials or protestations of innocence, he is going to be arrested, prosecuted, convicted, and eventually incarcerated. The interrogator seeks to convince the suspect that this is a fact that has been established beyond any doubt, and thus that any objective person must necessarily reason to this conclusion by persuading the suspect that he has been caught, that the existing evidence or case facts objectively prove his guilt, and that it is only a matter of time before he will be prosecuted and convicted. The interrogator seeks to alter the suspect's perceptions such that he comes to view his situation as hopeless and comes to perceive that resisting the interrogator's demands is futile. Once the interrogator has caused the suspect to understand that he has been caught and that there is no way out of this predicament, he seeks to convince the suspect that the only way to improve his otherwise hopeless situation is by confessing to the offence or offences of which he is accused. The second step of successful interrogation thus consists of offering the suspect inducements to confess, reasons or scenarios that suggest the suspect will receive some personal, moral, communal, procedural, material, or other benefit if he confesses to some version of the offence. Researchers researchers have classified the types of inducements investigators use during the normal step of interrogation into 3 categories: low-end inducements, systemic inducements, and high-end inducements. Low-end inducements refer to interpersonal or moral appeals the interrogator used to convince a suspect that he will feel better if he confesses. For an example, an interrogator may tell a suspect that the truth will set him free if he confesses, or that confessing will relieve his anxiety or guilt, or that confessing is the moral or Christian thing to do, or that confessing will improve his standing in the eyes of the victim or the eyes of the community. Systemic inducements refer to appeals that the interrogator uses to focus the suspect's attention on the processes and outcomes of the criminal justice system in order to get the suspect to come to the conclusion that his case is likely to be processed more favorably by all actors in the criminal justice system if he confesses. For example, an interrogator may tell a suspect that he is the suspect's ally and will try to help him out, both in his discussions with the prosecutor as well as in his role as a professional witness at trial, but can only do so if the suspect first admits guilt. The interrogator may also ask the suspect how he expects the prosecutor to look favorably on the suspect's case if he does not cooperate with the authorities. In a further variation, the interrogator may ask the suspect what a judge and jury are really going to think and how they are likely to react if he does not demonstrate remorse and admit his guilt to authorities. Interrogators often couple the use of systemic incentives with the assertion that this is the suspect's one and only chance, now or never, to tell his side of the story. If he passes up this opportunity, all the relevant actors in the system, police, prosecutor, judge, and jury, will no longer be open to the possibility of viewing his actions in their most favorable light. Interrogators rely on systemic inducements to persuade the suspect that the justice system naturally confers rewards for those who admit guilt, demonstrate remorse, and cooperate with authorities, whereas it invariably metes out punishment for those who do not. High-end inducements refer to appeals that directly communicate that the suspect will receive less punishment, a lower prison sentence, and or some form of police, prosecutorial, judicial, or juror leniency if he complies with the interrogator's demand that he confess. If, however, he does not comply with the interrogator's demands that he confess, the suspect will receive a higher sentence or greater punishment. High-end inducements may either be implicit or explicit. The important question is whether the interrogation technique communicates the message or is understood to communicate the message that the suspect will receive a lower criminal charge and or lesser punishment if he confesses, as opposed to a higher criminal charge and or greater amount of punishment if he does not. For example, interrogators sometimes try to persuade suspects that their behavior was merely an accident or a reasonable response to the victim's provocation or an act of self-defense. By portraying the suspect's behavior as an accident or reasonable response to provocation, the interrogator communicates that the suspect did not intend to harm the victim, that the act was therefore not a crime or a significantly lower level of crime, and that the suspect will therefore receive little or no punishment if he agrees to the interrogator's version of what happened. By portraying the suspect's behavior as self-defensive, the interrogator communicates that no crime at all even occurred and that the suspect will receive no punishment at all if he agrees to this version of what happened, since self-defense is not a crime, but a legally excused response to physical aggression. Sometimes interrogators use more explicit high-end incentives, such as telling a suspect that there are several degrees of the alleged offence, each of which carry different amounts of punishment, and asking the suspect which version he would like to confess to. Or the interrogator may explicitly tell the suspect that he will receive a long prison sentence, or perhaps even the death penalty, if he does not confess, and or may point out what happens to men of his age or men accused of crime in prison if he does not confess to the interrogator's minimized account. Sometimes interrogators who rely on high-end inducements will present the suspect with a simple two-choice situation, good versus bad. If the suspect agrees to the good choice, a minimized version of the offence, such as involuntary manslaughter or self-defence, he will receive a lower amount of punishment or no punishment at all. But if he does not confess, criminal justice officers will impute to him the bad choice, a maximised version of the offence, such as premeditated first-degree murder, and he will receive a higher level of punishment, or perhaps the harshest possible punishment. This technique is sometimes referred to in the academic literature as the maximization minimization technique. The point of high-end inducements is to communicate to a suspect that it is in his rational self-interest to confess to the minimized or non-incriminating version of the offence that the interrogator suggests. It is in the suspect's rational self-interest to do so because he will receive a lower charge, a lesser amount of punishment, and or no prison time. If he fails to confess, however, he will receive a higher charge, a greater amount of punishment, and more time in prison, perhaps even the death penalty, although it is rare that interrogators these days ever threaten a suspect with receiving the death penalty if he does not confess. To evaluate whether a particular interrogation is coercive, experts must determine the facts of the case and then analyze these facts in light of the extensive social science research literature on the social psychology of interrogation and confession. The expert must evaluate whether any of the interrogator's techniques, methods, or strategies were coercive by applying the generally accepted findings of the social science research literature on the subject of interrogation, coercive influence techniques, and false confessions to the specific facts of the case. In particular, the expert must determine whether the interrogator used any techniques that communicated, either implicitly or explicitly, that the suspect would receive a lower sentence, a lesser amount or type of punishment, or perhaps no punishment at all if he complied with the interrogator's demands, and or receive a higher amount or type of punishment, or perhaps the harshest punishment possible if he did not comply with the interrogator's demands. Social science research has repeatedly demonstrated that some systemic inducements, depending on the content of the inducement, how explicitly or vaguely it is stated, and the message that it communicates, and all high-end inducements are coercive because they rely on implicit and or explicit promises of leniency and threats of harm to induce compliance. Such promises of leniency and threats of harm are not only regarded as coercive in the social science literature because of the messages they convey and their demonstrated impact on the decision-making of individuals, but they are also regarded as legally impermissible by courts. The expert may also evaluate whether the interrogation techniques, either individually or cumulatively, had the effect of causing a suspect to perceive he had no choice but to comply with the demands of the interrogator, and thus whether the interrogation, in effect, overbore his will. Now, I think that's enough for today, so we will make a note of the fact that we are at number 18, police-induced false confessions. Roman V. Okie dokie. And maybe I'll get a chance to do the next part in the next couple of days. As I say, it might even take two two or three parts, because I see we've only got through, I would say, about a third. I think we've got maybe another third and then another third to go. I'm sure that, like me, many of you were reading through that, thinking of the techniques that Wiegert and Fassbender used, and also the Michael O'Kelly technique of I'm sorry for what I did, or I'm not sorry for what I did, but you've no other option. What I also find interesting is and it reminds me of the fiddler that used to play in the band with me 20 odd years ago. Very, very smart fellow, but hugely into chemistry. And I always remember the drummer in the band, who was actually, for a drummer, an incredibly smart fella, pointing out that because the fiddler had gone straight from school, straight to university, and then having got his various degrees or whatever at university, was then retained by the university to then become a lecturer himself. He was aware of the fact that some people can go through life always perpetually in the academic world. And I remember Hector saying something very significant to me, and that was that he wouldn't be surprised if the fella, his name was Paul, which of course a lot of very sensible people are called Paul. He said, well, he'll probably end up being one of these experts that people will call upon when needed, because he will become one of these people who knows more and more and more, increasingly more about less and less and less. So he said, you have to forgive him. Like, for example, a couple of times I caught him trying to put up disco lighting, and honestly, he hadn't got a clue. But you ask him something about chemistry, and he would know it off by heart, and particular aspects of chemistry. And so I'm kind of getting the sense that, as I say, with people who are involved in the academic world, they get to the stage where, as I say, they know more and more and more. They become real experts in their field. So this isn't by any means a criticism at all. I think when you focus on one aspect of work, that you get better and better at it, don't you? As you get older, I know for a fact I'm a far better teacher now than I ever was when I was first starting off in my mid-teens. I was 15 when I first started teaching professionally. So obviously I know a lot more now than I did then, specifically about music. So I think we have to give this Dr. Richard Leo very, very much credit, because clearly what his affidavit provided was the, obviously probably not all the evidence, but a lot of the evidence that was required by Judge Duffin to make his accurate assessment of Brendan. So as I say, I'm really hoping that I can get hold of Dr. Leo in the not too distant future. And also Tracy Keogh. I'm hoping that she'll be able to join us. And if the dude ever responds to his scurrilous accusations, which I have since proven are scurrilous, then maybe he'll even deign to join us. So yes, Mark, is Mark there? Is he? Wow, that would be amazing. Yes, he is. Oh, good evening. Good evening, Mark. How are you doing? Good evening, as I say, dark side of the moon. And Jane, I'm sure you're reveling in the glory of having beaten me 26-0 in the mastermind. Okay, as I say, we'll carry on with part 2, possibly tomorrow, or if not within the next couple of days. And as I say, watch this space, and I'm hoping that Dr. Richard Leo will join me. Tentatively, we're looking at the beginning of July. He's going to take a well-earned vacation, and So anyway, we'll catch you all soon. As I say, just to say, I enjoyed obviously the rally. I thought the mastermind was great fun. We actually recorded that the weekend before, and what was funny was that the dude was actually reluctant to do it at first, but I think even he agreed that it was good fun. It was a good laugh, and so anyway, yes, the rally went well. We didn't end up having the after party after rally after rally after party that we were going to have, but never mind. Maybe we'll have that next year. Okay, take care all, and we'll see you soon. Bye for now.